No, that's not true. None of the agents involved used anything from the facts in that immunity case to prosecute him. This is all new stuff that we got independently on our own. I assure you of. Now,
If
MacLaughlin and Lackner
hadn't been shielded by
absolute immunity,
I don't think they would have been around to be investigating and fabricating evidence and lying about me and prosecuting me in my trial. I think they'd have been in prison or disgraced, disbarred, fired. Okay, we're talking about United States versus Sewart, criminal number 0804, District of Minnesota. You can look this up on Pacer. Now, in this video, I'm going to show you how in this case, there were a lot of allegations made against the two prosecuting and appellate attorneys in my case, David MacLaughlin, James E. Lackner, right? I think I've showed you their names over and over again. And in this case, I'm going to show you the case was dismissed. The indictment was dismissed with prejudice, right? So it was found that these people had basically told somebody that he had
immunity
and then used what he told them with that immunity agreement against him, tried to
prosecute him anyway.
And if you think about the stuff that I've been telling you in my case with Patrick Doles, right? He thought that he had immunity in my case, right? And then in my case, they're presenting to the jury a witness from Bank of America who they basically claim is a disinterested third party, doesn't stand to gain a $250,000 judgment. Okay, so talking about the first witness in my case, the government's expert witness from Bank of America, right? Let's go back to the trial transcripts where she testified. That's case 10 CR 0326.142, and this is on May 17th, 2011, and this is in front of the jury. Now they've got her expert witness, Kelly Bodeker. We're going to go down to page 15. Here's the question on line 7. This is the prosecutor. He asks her, and therefore, what is the importance to the lender that there is a real, genuine bargain between the buyer and the seller? Now, this is their expert who they say is an expert, right? I say she's just disguising herself as an expert. She says her answer as an expert. Well, when you are looking at a purchase transaction, there is really two different types of purchases. You have a non-arm's length transaction, which means that the buyer and the seller are not related in any way. Or you can have a non-arm's length transaction, which can be an instance where there is some relation between the buyer and the seller. Sometimes they could be between family members. Maybe a child is buying a property from a parent or something like that. That would be an example of a non-arm's length transaction. Now, didn't she just describe two unique and distinct scenarios and situations, but then label them as the exact same thing? This is the expert, right? Is it corrected? After that ridiculous answer, we're given these ridiculous statements. And what did my attorney argue? That this was more prejudicial than probative because it was going to confuse the jury. Is this not exactly the type of dumb shit that would confuse a jury? Then they hide it in the docket. The way that the government quotes the transcripts is not according to the court rules. They quote them as trial transcripts in volumes. The way that the government quotes the transcripts is, look at the district court document. There is no reference in any entry on the district court for the criminal case for volumes. And I was told by the district court that the only way I could find that out is if I clicked on Pacer each individual transcript to see if the volume matched up with what was being pled out in the appellate court. But that's against court rules. It's supposed to clearly... See, it's against court rules. It's supposed to clearly correspond to the district court criminal docket. And it's almost like it's done purposely to disguise the record. And then if you remember, the transcript that they quoted again and again against me, that would have been volume 10. You can go look it up in the criminal appeal. I think the case is right there. There's the ID entry 3902941. They use volume 10 several times, maybe like on quite a few pages. It's not even available to the rest of the world until July 9th, 2025, right? And this is all the way back in an appeal from 2011. Then you remember James Lackner says that we only objected to certain exhibits, nothing else, right? That was a flat lie in my appeal, right? So I like to show you from the record, from their own words, the transcripts, how they're lying, right? So criminal docket 10 CR 00326 DSD. Now this is my case, but the same prosecuting attorneys that were in that other case, the same ones that told Patrick Doles he had immunity, same ones who put that Bank of America witness up there disguised as, a disinterested third-party witness expert. So now keep these dates and document numbers together. So let's go down to document 142. 142 is the transcript. This is from trial. We got to go back to 134 to identify what part of trial it's from. But we're going to do that. 134, transcript of trial held on 5/17, okay? And that's document 142, and that was 2/7/2012. 2/7/2012. Keep that date in mind. Let me show you why that's an all-out lie. What he just told the appellate court is that we didn't object to this. We just objected to some specific exhibits, nothing more, and that was insufficient. So these are the actual transcripts, document 142 from trial May 17th, 2011. Remember, this transcript was available to him since February 7th of 2012. We're going to go down to page 12. And on page 12, we've got our first objection, and it's lack of foundation. And it has nothing to do with an exhibit. And we're going to go down to page 13. Mr. Bergeson, again, objection, Your Honor, leading the witness. And here we're talking about desirability of neighborhoods. And then we're going to go down to 63. We have another objection. Mr. Bergeson, objection. She's not the representative of the lender. So here she's speculating about what somebody else would do. She's disguised as a non-interested third-party witness, remember, not somebody who is, one of the alleged victims who stands to gain a $250,000 judgment if I'm found guilty. None of that's revealed to them. She's just a disinterested expert witness, according to the government. And so we've made another objection down here at 63, which is not to an exhibit, it's to testimony. So again, all out lie, while they're denying me the record in which to dispute this lie. And remember, this is Doc 142, filed February 7th, 2012. And it's for the trial May 17th, 2011. It is David MacLaughlin, and it is Kelly Bodecker, right? And those objections were on 12, 13, and 63. And they were all before cross-examination while she was on direct examination by Mr. MacLaughlin. 3 separate objections that have nothing to do with exhibits, have everything to do with witness testimony. February 7th, 2012, that transcript, the redacted transcript, was available. Of course, he had the original transcript even before that. He makes reference to volumes, but there's a number of misstatements on the record. And this was filed 11/14/2011, and the government files their brief all the way down here on 4/19/2012. So more than 2 months after there's a number of misstatements on the record, and having that redacted transcript, and they had the non-redacted transcript for a lot longer than that. So there's a number of misstatements on the record, and they knew or should have known, and most likely clearly knew. I mean, wouldn't you agree? They knew that the objections were made when they said that there were no objections made, or at least it was their obligation to read the transcript and know that that wasn't true. Wouldn't you agree? There's a number of misstatements on the record, and we can't even get the transcript. So
Spencer's the court was a bright, tenacious defendant who's made numerous claims which are belied by the record. That record, which should, in the government's view, be cited and relied upon in the government's refutation of Spencer's claims.
So they're going to use the record to prove me wrong. That's what they're saying here. And they want to respond
from the record. Here, there was no Daubert violation. Larson did not testify as an expert witness, but rather as a fact witness with technical knowledge.
Okay, let's go back to Doc 148, the trial transcript, real quick. Was that a computer expert that works for the IRS? Did you specifically identify to that computer expert? Did you give permission to that computer expert? Okay, let's go back now to the government's well-founded response from the record.
Larson did not testify as an expert witness, but rather as a fact witness with technical knowledge.
This is Doc 215, United States response, opposition to Spencer's motion to vacate, set aside. They finally filed this on May 30th. This is their well-founded from the record, 215. Now, this again went to the government's crucial piece of evidence that they say they had on me. It was this resume, right, that I was going to give to the mob boss or whatever.
All that stuff that's going on, they violated my attorney-client privilege with my tax attorney, went in there, said he's just a CPA, right, figured out a lot of my defense, changed up their trial strategy. So all those things that I've alleged in mine, let's look at the case, because this case happened before my case. This is a good character assessment, because from this case to my case, do you think it's more likely that Lackner and David MacLaughlin, their character changed? Or do you think it's more likely that maybe their methods changed, their modus operandi changed, right? That's probably what changed. So this is the case right here, guys. You can get this case on Pacer. But in this case, the defendant had provided some information in a use and fruits immunity, or a use and derivative use immunity, also known as use and fruits, which is like the full immunity. And I guess you could distinguish this from the type of immunity that was semantically written into Patrick Dole's, my co-defendant's plea agreement, allegedly. I've never seen the plea agreement, but as you know, Patrick Dole's believed when he testified against me all the way up to when he was sentenced that he had immunity for his testimony as a key witness in 2 government cases.
And then they said, no, you don't.
Now we go into this case, and this guy had provided the government with some information under a proffer deal where it was use and fruits, and then they went ahead and they indicted him in this case. Now in both cases, it involves protected information, doesn't it? Like this guy gave him some information, he was supposed to be protected, and then Dole's believed all the way up to when he was sentenced that he had
immunity.
And then they said, no,
you don't.
I gave my attorney, Bill Hogle, my tax attorney, some privileged information that was supposed to be protected. Then when I was in fighting my appeal in prison now, after all this corrupt stuff had been done, and they flipped my tax attorney, previewed my defense, and I'm in prison working on my appeal, and I'm thrown in the hole because Mr. MacLaughlin had reached out to the prison, right? I think I've shown you documentation that I uncovered that shows he did that, coincidentally. And 12 inches, a foot of my legal work disappears, right? Which also should have been protected, right? United States versus Sewart is really a good comparable case if we're going to evaluate the conduct of the United States attorneys who prosecuted me. So do we see a pattern here? Keep in mind that everything that happened to Mr. Jeffrey Sewart, exact same prosecuting attorneys in my case and on my appeal, because both of those attorneys were involved in this case, United States versus Sewart, and it happened just 2 years or so before my case. But during those two's investigation into my case would have been occurring exactly during this time. Remember, the facts in Sewart's case is that he made this agreement and did this proffer back in 2003, and now all the way years later in 2008, they're indicting him, and he's saying,
well, hold on a second. second. All that stuff I told you I had immunity for, and now you're using that to prosecute me.
And the government said,
Nope, that's not true. None of the agents involved used anything from the facts in that immunity case to prosecute him. This is all new stuff that we got independently on our own. I assure you of it.
Doles believed all the way up to when he was sentenced that he had
Immunity.
And then they said, no,
you don't.
And it had been very difficult to prove this. But luckily, there was this Castigar versus United States Supreme Court case, which gave the defendant in this case the right to have a hearing, which places a heavy burden on the government. Otherwise, we would never have been able to develop this record. It would have just been hidden, slid under the rug like a lot of stuff in my case. Okay, so here's the case right here, guys, right? And the government comes down here on 1/8/2008, document 1, indictment to Judge Donovan. That's despite the fact that Sewart's proffered testimony was immunized.
Nope, that's not true. None of the agents involved used anything from the facts in that immunity case to prosecute him. This is all new stuff that we got independently on our own. I assure you of it.
Now, when Sewart challenges this, the government, through AUSA MacLaughlin, vigorously defends its position and argues that, everything they're doing in this case is
100% kosher, 100% valid. None of the agents involved used anything from the facts in that immunity case to prosecute him. This is all new stuff that we got independently on our own. I assure you of it.
MacLaughlin making these arguments in court in this case. Now, remember, the government is arguing against this guy, saying that everything was kosher, everything's above board, and a lot of the stuff they filed, right? They want to, let's look down here, let's look at the docket and just see what it says. Memorandum by USA, motion to exclude, letter to district judge, motion to seal document by USA, sealed document. Now there's a sealed document number 60. And finally down here, and so the report and recommendation, which I'm going to show you guys what you guys can see, you can get off pacer, but this was sealed for a while, right? They made a motion. They didn't even want people to know that this happened, right? While this is going, okay, sealed up for a while, this guy had to make a motion just to unseal it, right? So they're trying to conceal what happened here. Would you agree with this? What happened? Let's go up to the top of the docket. David MacLaughlin and James E. Lackner indicted this guy, Jeffrey Sewart. And Jeffrey Sewart said, whoa,
hold up now. Back in 2003, we talked about this. You gave me immunity. And
now they're like,
No, we didn't.
Right?
This ain't got nothing to do with that.
And so this guy files a ton of motions.
Hits him with a bunch of paperwork.
And then David MacLaughlin and them, they start responding, arguing vigorously.
No, that's completely untrue.
Sealing documents like in 52, sealing documents in 60, finally getting when they lose, and they lost, right? Which means that the court found that them and their agents were not truthful. This guy had
immunity.
You told him that. That's what the docket actually says. So if we go to that docket, that's 8 CR 00000. Okay, so this is document 65 in that case, 8 CR 00004 DWF SRN. This is page 1 of 3. If we look down here, the United States called 4 witnesses. Each of them testified they had
no knowledge whatsoever of the content of the immunized statement
given by the defendant on December 6, 2002. So we're going all the way back to 2002, and this is Doc 65. That's what the government is allegedly arguing there. And so what MacLaughlin is doing here is he's vouching for his agents,
Marcus Lane and Noah Boshart,
and these were the ones who
formed the core of this investigation that
sought to use this immunized
evidence
against the defendant.
However, when you actually get to, uncover the truth behind what the prosecutors say, you often find out that the truth is completely different to what they say. And that's what they were starting to find out in this case. They had 2 separate hearings. And in the first hearing, the defendant did the best job they could, but the magistrate was like,
well, no, I'm going to give it to the government.
Defendant said, well,
hold on, you can't do that. The government bears a heavy burden here. In this case, is going to be decided on credibility, theirs or mine.
So Donovan Frank, the judge, if we look in document, this is document 68, filed 8/1/08. Donovan Frank here denies the government, who argues that
there shouldn't be another hearing. We've already proven our case.
And the court is like,
yeah, I'm kind of aware we don't have to have another hearing, but we're going to have one anyway because, I don't know if I trust you.
In this case, they got a second hearing. And remember, they put these time limits on you. They want to time bar you. They want to do a lot of things to prevent you from ever getting a second hearing.
Things start to come out. You're able to expose the lies when you're able to really develop the record. If you don't get hearings, you can't develop the record.
When this defendant was granted a second hearing, he was able to establish that one of the IRS agents had
possessed the immunized evidence.
And he wasn't supposed to have it, and he had it for months. He even
asked for this information. And
the other FBI or IRS agent
Boshart
likewise testified, again, inconsistently over these hearings about how she came to know the same information.
Right, real suspicious, real funny explanations that really started to show that they didn't make sense. They really didn't corroborate each other. And it was now starting to become obvious that we can't trust what
David MacLaughlin
previously asserted. So Judge Frank gets involved, right? Looks at the report and recommendation, looks at the government, the evidence.
Now let's have a second hearing.
Right? And then in that second hearing says,
no, government, no, I'm not buying this. I'm going to go ahead and dismiss this indictment with prejudice.
So when you think about this case right here, because prosecutors have immunity, like I said, and you can't challenge people to duels or anything like that. So when they do these type of things, it's just swept under the rug, and they make motions to seal it. Like you see in this case, the government actually had this report and recommendation, all this stuff sealed. And if we were to kind of compare off, what happened in this case to maybe like civil liability, or if you said that we're just going to remove the immunity of the government, right? It might be equivalent to something like, fraudulent misrepresentation or constructive fraud, especially given the fiduciary like duties that prosecutors owe the court and owe the public. Rather than even bringing this case, right? Argue and have all this prolonged, litigation, trying to cover it up, trying to seal it. Isn't there a higher standard, right? The model rules of professional conduct, in fact, Rule 3.3, it actually prohibits lawyers from making false statements or from failing to correct false evidence. And I think there's some evidence in this case that, at least one of the United States district attorneys knew that this was going to be a problem and warned people in the case, like, hey,
that's an immunity problem.
Right? And despite that,
the problem persisted for some time.
And despite whatever the government knew or should have known, they brought an indictment against this guy and put him through this entire legal process and ordeal. And let's just look at some hypothetical liability if there was no
Immunity.
If
MacLaughlin and Lackner
hadn't been shielded by
Absolute immunity.
I don't think they would have been around to be investigating and fabricating evidence and lying about me and prosecuting me in my trial. I think they'd have been in prison or disgraced, disbarred, fired even before I ever got to trial. I mean, you know how there's ambulance chasers, right? Personal injury lawyers who pursue, injuries. They chase the ambulance. They're so hungry, so thirsty for the cases. You've got those class action lawyers, right? They want to get that big money. Real greedy people, these lawyers are. Not all of them, but a lot of them, right? If there wasn't this immunity, right? Don't you think there'd be like, if there wasn't immunity and this guy just got indicted and then proved his case that he had immunity, they put him through all this, how many lawyers do you think would have been at his door like, hey, let's sue the government, right? Just like, whenever you do like a dairy product or a farm product or something, right? You look for that government subsidy, you're going to start a business. What kind of government money, right? Because that's a sure thing, right? It's like insurance money almost, right? It's better than that. So without that
Immunity, right?
I mean, there'd be a lot of, and guess what? That's why there is immunity, because they do this so often. They violate your rights so often, and they take steps to cover it up, and then they keep the same people employed, even promote them to judges. Remember, I told you, David got one of the team promoted to referee, right? David was writing a letter for this judge, right? This judge right here, she's a judge now, but she was on the team, right, since 2010, and she was in 150 meetings. Now, what kind of meetings do you think they're having if they have cases like this, right, where they got to go to court and prove that they weren't, misusing protected material, right? Protected information, right? Just like with me, they're going to court now and they've intruded into my attorney-client relationship, and they have to prove that my tax attorney really wasn't an attorney, he's just a CPA. So when you think about all the time and stuff they got to spend fighting these kind of cases and coordinating this stuff, and they've got 150 meetings, right? What are they talking about in those meetings? And so, they didn't like
Judge Frank
in this case, right? So that's what I say. Do you think their character changed, or they just changed their modus operandi, right? When they got their opportunity to put a member of the team to referee, they can now ensure that these rulings like Judge Frank and getting these indictments, this embarrassing dismissal of these indictments and making us look bad, we can even decrease the possibility of that happening even further. So I digress now. Without
absolute immunity, right?
This defendant could raise a Bivens case, a Fifth Amendment due process violation, right, for his immunized testimony being used against malicious prosecution, abuse of process case, right, a breach of implied contract, violation under the proffer agreement terms, right? He'd have some claims, wouldn't he? And he'd have, without that
immunity,
he'd have some attorneys beating his door, right? They want to get a piece of that action. They know you got a claim. And the civil liability might be over $1 million if you think about it. I mean, look at all this, what this guy had to go through, right? Because of these two. True or false? And wouldn't he have some criminal liability too without that
absolute immunity?
I mean, the federal government, I know for a fact they did this in Puerto Rico. There was a civil rights case where they paid a family, Robles, they paid this family something like, and you'd have to look in the case of Aaron Maldonado, right? But this sergeant or Captain Maldonado was a police officer, and he had failed to prevent his officers from abusing a detainee, and that detainee died. I'm trying to remember the facts. And he was held responsible, but only after the city was sued and there was this big $1 million judgment. So take away immunity for these prosecutors. Like I said, you'd have all these attorneys beating down their door because they'd have these cases, because this happens all the time, right? And that's why they try to cover it up. One, that's why they have immunity. For two, they can afford to pay on these cases, right? Look at what they do for ineffective assistance of counsel. They give you the Strickland versus Washington insurance policy that bulletproofs.
Are you a criminal defense attorney? Well, let me introduce you to Strickland and Washington attorney insurance providers. Guaranteed foolproof coverage for all criminal malpractice claims. Let's go over some coverage highlights, like guaranteed enrollment, zero accountability, and we accept reasonably deficient and probably would have lost anyway. Not a problem with Strickland and Washington Insurance Company.
insurance policy that bulletproofs any criminal defense case from any malpractice claim whatsoever. But back to how this relates to
MacLaughlin, if
this immunity wasn't there and they were paying out these claims, so sooner or later prosecutors would start getting criminally prosecuted because the government would be mad. They're like, no, you guys got to stop doing this. You're costing us millions. We're gonna put you in jail. Eventually that would happen, right? So you'd be looking at some time. You'd be looking at some real time without that. Now I'm just asking questions here, right? If we really had equal protection of laws and they didn't have that absolute immunity, isn't it possible, maybe even likely, that by the time 2010 rolls around, United States attorneys
David MacLaughlin and James Lackner
wouldn't even have been around to prosecute me, right? Because they could have been fired or imprisoned, correct? And considering all the dubious stuff that happened in my cases I've shown you, and you haven't even seen the best of it yet, and you start to get to know
David MacLaughlin and James Lackner,
right? And you see them in other cases, right? The cases we're allowed to see, because you see they get to seal virtually whatever they want, right? And most of the time, you don't even get a first hearing, let alone two hearings. But you see when you start to get hearings that it really exposes them to who they really are, right? And from 2008 to 2010, do you think they changed their character, or do you think they just changed the way that they operated and took steps to conceal their illicit conduct? What do you think? If you think that could be the case, and you look at the 99.6% conviction rate, could all that be a reason to do your jury duty and nullify every federal case? And this really exposes, right, the structural imbalance, the equity in the courts, the biasness, the accountability in the court system, because despite the court's explicit finding that the government violated constitutional rights, what professional sanctions, what criminal referrals, what civil consequences followed for MacLaughlin and Lackner? As far as I can see, there were none. And so this obscures how serious this conduct is. Nobody really notices it because it's swept under the rug. It's not even considered. It's just like, oh, well, government made a mistake. The government makes mistakes. This is serious conduct, right? Without that immunity, if this happened in the civil sphere, people are paying real penalties. People are going to prison. They're just allowed to sweep it under the rug, hide it when they can with sealed documents, and then move on to the next case with the knowledge now of, okay, we can't do it that way. So when we look at this case and then we look at my case, there were two credibility contests between the defendant and
David MacLaughlin.
And
David MacLaughlin,
Awesome.
both of those. So it appears that when the truthfulness of his assertions are really submitted, right, to a thorough examination, that they come up lame. And I would argue that there's more evidence of
David MacLaughlin
and
James Lackner's
misconduct than there actually is of any wrongdoing for me. Remember, they said that when I denied any wrongdoing, any criminal conspiracy, and they said that my trial testimony
contradicted every witness in the trial.
and that these were
Concocted stories. It was clearly false.
I
Lied about everything. To believe Spencer is to disbelieve every other witness in the case.
and they tried to get
Perjury.
against me. And at sentencing, they only needed to prove that by a preponderance, the lowest burden of proof. And they couldn't prove, despite saying I lied about
About everything.
They weren't able to prove that I lied about anything.
And here they are in this case getting indictments dismissed in similar circumstances where somebody's protected information or privileged and protected material is being compromised by misconduct by the
Prosecution.
who is then taking steps to conceal it and cover it up. Just 2 years before my trial and while the investigation into my case is ongoing. Now, do you think their character changed from this case to my case, or just the way that they operated to conceal their crimes? I'm just asking questions here. What do you think? And remember, they're out on the street. They're calling me a fraudster. They're putting Bank of America witnesses up on the stand, telling the jury that they're a disinterested third party. Doles has recanted his testimony. They're saying it's just impeachment evidence. We've objected to their star government witness, the Bank of America expert, who stands to get a $250,000 judgment, that they're hiding from the jury, concealing in the record, making it hard for us to even know that this is going on, while they're denying you transcripts and misquoting the record on your appeal. And you remember Doles thought he had immunity all the way up to 3 weeks before he got sentenced. A lot of parallels if you really think about it, right? A lot of same character conduct, even if the way they go about it has changed a little bit. So 2 criminals, under color of law, prosecuted me and then took steps to conceal what they did, their fabricated evidence, their perjurous and deceitful, outright lying testimony, and then deny me fair appeals post-conviction. I think it's safe to assert that most prosecutors would go through their entire career without having an indictment dismissed with prejudice, right? I mean, these kind of dismissals are extremely uncommon, reserved for serious constitutional violations, and really signals a failure at the highest level, and that's something most assistant United States attorneys ever encounter. So I'm just going to ask some questions here.